Hello and welcome to another edition of Legal View with Michael Ayala. This is just a video newsletter of the things that I've learned this week in true crime and in trials and in legal news. And it's been quite a week. But before I get to that, I just want to let you know I just got back. I picked my son up. He was there. He was in UNC Charlotte, the college, for a couple of days, 3 days, 3 full days, 3.5 days for a sports analytics summer program. It was free. It was fantastic. He loved it. Learned a lot. You know, when you get kids 15, 16, you just got to start exposing them to different things so they can begin to form an opinion about what they want in terms of college, maybe a career, things that might interest them, give them opportunities to sort of marry the things that they're interested in. He's good at math. He loves sports. So the opportunity to connect those two things was what this camp was all about. It had soccer, which is his sport, basketball, football, ESPN folks were there. It was just a fantastic camp. So I just want to give a shout out to those guys at UNC Charlotte, Mr. John Tobias. Check him out. He has this program every year. So if you want to go there next year, and it's a free program, it's fantastic. So he runs a not-for-profit. Anyway, let's move on to the top 3 things that I learned this week. And again, it's been a busy week. First thing I want to talk about is obviously Carmelo Anthony continues to dominate the news, especially in social media. What happened this week, big developments in his case. A group of private attorneys have decided to step in and take over the appeal of his case. They are going to do it pro bono. What that means, for those of you who don't know, they are not going to charge a dime. It is a team of 6 attorneys with civil rights backgrounds, appellate backgrounds, post-conviction relief backgrounds, so heavy hitters with experience in the specific area of appeals. So, what does it mean? Initially, because Carmelo Anthony, after the trial, filed for an appeal, but also filed as indigent, saying as an individual he had no money, the appellate division of the public defender's office was going to take over the appeal. They will hand over the case now to these private attorneys. Most of these attorneys are from the Dallas area. It was put together, interestingly enough, by Lee Merritt. You may remember him. He was representing the family in the Ahmaud Arbery case and has been in involved in a number of high-profile civil rights cases. That's kind of his specialty. He's one that gets involved with suing police officers and things of that nature on the federal level. So he's been very vocal towards the end of the trial and after the sentencing about this case. He feels the sentencing was much too harsh. Was talking about some of the things that went on in the trial. So what he did was he went out and put together a team, and I'm going to call them the Justice League. The Dream Team is obviously taken. So I'm going to call them, this is the Justice League of Attorneys coming in to step in and take a look at this case. I want to give you an idea who some of these people are. Russell Wilson, he's going to be the team lead. He's a board-certified criminal law attorney and former Dallas County prosecutor. He previously directed the Dallas County District Attorney's Conviction Integrity Unit. I like the sound of that. Gary Bledsoe. He's a veteran attorney, longtime president of the Texas NAACP, specializes in civil rights. Michael Ware, a prominent defense attorney, director of the Innocence Project of Texas. These are serious dudes. Brooke Cluse. She's a civil rights attorney practicing with the nationally recognized Ben Crump law firm. We all know Ben Crump. He's involved in the George Floyd case. Got a huge settlement for them, largest settlement ever, was involved in that and in any number of cases. Whenever there's a case that involves perhaps some form of injustice, not saying that's happening here, that's what they're going to try to find out. You'll see Ben Crump involved, and he too has become more vocal. As a matter of fact, before I go on, he's sort of a master at creating the narrative, and he's created a website called I Stand With Carmelo as part of this effort to begin to change the narrative about this case, which, as we know, is very, very important In cases like this, something that I've been critical of the defense team of Carmelo from the beginning and not doing more to create a positive narrative around Carmelo and who he is and who his family is. He kind of did his job, and that was just about it. Two other folks, Sean Deredia, a North Texas trial attorney and founder of the Deredia Law Firm. He specializes in aggressive criminal defense and trial litigation. And Justin Moore, a Dallas-based civil rights and criminal defense attorney with Stafford Moore, and he's known for handling high-profile systemic justice and defense cases. So they've got just about every angle covered with this new team. So what does it all mean? That's what I wanted to answer for you folks today who are checking in. What appeals are is something that you need to understand. You can't go in and bring in new evidence. An appeal is a look at the four corners of the trial. Those are the terms they use. And what that means is they get to comb the record and look at decisions made by the judge, evidentiary decisions, decisions on who can testify to what. Decisions, for instance, on the Batson challenges. Did he make the right decision in allowing the prosecution to get rid of those female jurors? They'll take a look at that, for instance. And they'll determine if there were errors made. They will then put together a brief and argue it in front of the judge. Prosecutors will get an opportunity to respond and argue in front of the judge or judges. Usually from the appellate courts, there's a panel of judges. And they'll argue that these errors affected the trial. Now, if they find errors in the trial, there's a second prong that needs to be met. Those errors have to have affected the outcome of the trial. So if errors are found, there was an evidentiary problem, there was a ruling on a particular charge to the jury that was wrong, then it'll be the burden shifts to the prosecution to show that that error did not affect the trial or was harmless error. You may have heard that before. It was harmless error. And the burden is beyond a reasonable doubt. They have to show that that error did not affect the outcome of the trial beyond a reasonable doubt. If they're unable to do that, the appellate court will order a new trial. Now, I want you to know, a series of harmless errors could add up to enough for the appellate court to say, hey, none of these individually are enough. This little evidentiary ruling here was a problem and was an error. There was an error here in terms of the charge that was read to the jury regarding the charges they were going to consider in the case was an error. Individually, they're not enough, but when you start putting them together, it creates enough that it's no longer harmless and we need a new trial. So that's a possibility as well. So let's take a look at some of the things that they might be looking at based on their background. You can really see who these attorneys are and see where they might be going with some of the challenges here and the things they may be looking for. Now, again, we're at a little bit of a disadvantage because we do not have the actual trial record. I do not know, nor does anyone at this point, know what motions were filed by the defense, what evidence they tried to get in and was denied, if any at all. Prosecutors, same thing. If there were certain witnesses they wanted to testify, weren't allowed to bring in, those types of things. We don't know that at this point. That would be part of the record, and when that gets released, we'll know and we'll talk about it then. But that's what these attorneys will be looking at. So let's start with number one, and that's in jury selection, right at the very beginning. Those Batson challenges, 3 black women, they were educators. This is well documented. They were removed by peremptory strikes by the state. They said, look, we don't want them here on this jury. So they were removed from the panel. Now, you can't just remove people because they're black. You can't remove them for their color, according to the Constitution, their gender, or because of their sexual orientation. These are protected classes. I don't know how long they're going to continue to be protected classes, but they are protected classes. So once that happens, the defense raises the objection, which this defense did. Then it's up to the state to give a reason, and it has to be a reason other than race, gender, or sexual orientation as to why they want those jurors off the case. In this instance, the reason that was given was they were educators in the Collin County school system. Because Carmelo Anthony and the victim in this case were both students in a Collin County public school, They felt that that was enough, that they could not be fair and impartial. Meanwhile, during voir dire, they were asked directly, could you be fair and impartial in this case, even though you're an educator in the Collin County justice system? And they said yes. Oftentimes that's enough. But in this case, it wasn't. So there might be a presumption that they were looking to get rid of them because they're black. They gave their reason. The judge thought the reason passed muster. And again, it is a very low bar. The judge has to just have a rational reason. That could be an error. Appeals court could look at that and say, it's not rational that just because they taught the system, there was no connection between the defendant and these women. They never taught him. They never even taught in the same school. Maybe they teach elementary school and, he's a high school student. So the reason wasn't rational. We'll have to wait and see. But that's the kind of thing that they'll be looking at and asking for. The other thing is, of course, they would look at if there are other educators who are not black on the jury. And in fact, there was. But apparently there was a woman on the jury who was a teacher at a beauty school. And so I don't know if the court would look at that and say, well, you didn't want these educators. But the reason given was not because she was an educator, but because they worked in the Collin County school system. So that might not line up, but certainly it will be raised by these attorneys. There was another issue I think they'll certainly look at. The defense wanted the lesser included charge of criminally negligent homicide put in front of the jury. This defendant was charged with murder. Lesser included charge was manslaughter. That was given to the jury. They also wanted criminally negligent homicide given to the jury. The judge said there wasn't enough evidence for him to let the jury consider that charge. And I'll tell you why. The evidence was that Carmelo Anthony took his hand, put it in his bag, had it on his knife, and told these guys when they said, hey, you don't have anything in that bag. He said, oh yeah, touch me and find out. To be guilty of criminally negligent homicide, you have to partake in a substantially risky thing that you're not aware of, could cause serious harm or death. So the thing that you engage in, you're not aware could cause serious harm or death, but you engage in it and someone is seriously hurt or dies. By putting his hand on the knife and saying, touch me and find out, the court probably felt he was aware that he could cause harm. Therefore, manslaughter was fine, because if you're aware that you could cause harm, or you're aware that you could do something reckless to cause substantially bodily harm or death, then you could be considered manslaughter. It could be considered manslaughter. And of course, if it was intentional and you had the idea you wanted to cause serious bodily harm or death, then it's guilty of murder. So the judge felt that those top two charges were okay, but not criminally negligent homicide. If an appeals court feels that that was in error, they could say that was an error. But the question would become, would it be enough to change the outcome of the trial? I'm not sure it would, because the jury already rejected the lesser charge of manslaughter. Criminally negligent homicide actually falls below that, because now we're talking about less awareness of what was going on and the harm you could cause. So if they rejected the manslaughter, that he was aware but reckless, they probably never would have gotten to the criminally negligent homicide. So the judges may decide that's in fact harmless error. So that'll be in play. The other thing that I think that's interesting is, because of all the publicity surrounding this case, I always wondered why there wasn't a change of venue. With all the emotions in the case, could they find a true, fair, and impartial jury? Presumption is they did, but they'll be looking into that. I do not know at this time if the defense filed for a change of venue in this particular case, and the judge denied it. If he did, that will certainly be looked at. There'll be a question as to whether it should have been moved. But again, all these presumptions are in favor of the prosecution, because appeals courts do not want to just willy-nilly throw out convictions and all the work that was done. As a matter of fact, the statistics are very dire for overturning violent crimes, convictions on violent crimes across the country. I think the number is only 6 to 8%. It rises a little bit when it comes to murders. They're much more complex, but the numbers are still very low. So just remember that it's not going to be that easy, even with these truly experienced and talented attorneys. The evidence that was put out, they're going to take a look at that. A lot of people, myself included, have looked at that evidence and said, wait a minute, why couldn't they, with all the technology we have today, this is the best that they could give us? Or this is the best that they could give this jury? Was it tampered with? Was there stuff that was there but not shown to the jury? All of those things will be looked at and determined if there were issues that need to be dealt with on appeal, which would then cause the case to be sent back if in fact it was found not to be harmless error. So all that is in play now that these attorneys are involved. I think a lot of people feel good about the fact that these are very experienced attorneys and they're taking a look at it. As I said, they've taken this case pro bono, which means they believe in what they're doing. They are going to put their best foot forward. They're going to try their best to figure out if Carmelo Anthony received a fair trial. That's what this is really all about. That's what this appeals process is for. That's why it's built into our Constitution, that these processes are there for defendants to ensure that before we take their liberty away, we make sure that they had a fair trial. So it's not about you want Carmelo out, or he's not guilty of something, or this was in fact self-defense. That's not what's happening here in the appeal. If a new trial comes up, that may be the issue, but it's not in this part of the trial. They're not going to be able to bring in a new witness that says, oh, I saw this. None of that. They will be taking a look at the evidence and some of the testimony as well of these witnesses to make sure there was no shenanigans there. There was some speculation about witness tampering. I could not find anything that suggested that actually happened. So that's where we are with the Carmelo Anthony case. We just have to wait. Now it becomes a waiting game for a couple of things. One, for them to go through the process of going through the evidence. It will take a tremendous amount of time. And also waiting for them to release the transcripts of the trial, the full transcripts, the motions, the decisions made by the judge, so folks can get a real look at it. The more you shine the light on these things, the better people feel about these decisions. Part of the problem in this case was not allowing cameras in so everyone could see and judge for themselves the evidence that was being presented. And now we're in a situation where, yes, they gave the evidence out, which wasn't tremendously helpful. But also now they need to release the trial transcripts and let us know what went on and what all happened before this thing actually went to trial and during the trial itself. A lot of people have been complaining about the 35-year sentence for Carmelo Anthony, saying it's too long. So I wanted to look into that. Is it in fact too long? Carmelo Anthony, no criminal history. He was a juvenile, 17 at the time he committed this crime, but he was tried as an adult in adult court. He committed a violent crime. And so I compared that to what was going on nationally, or what the statistics say for someone in that position. Now, I do want to put one caveat out there. Carmelo was sentenced by a jury. Only 6 states in the country still allow jury sentencing in non-capital cases. Texas is one of them. In Texas, the defendant has the option. He can have the judge sentence him or the jury. The defense chose the jury in this case. Why? We don't know. I can speculate. I believe one of the things they saw in this case is that they would have a tough time winning on the self-defense, considering who the defendant was and the town they were in and the circumstances. And the sudden passion aspect, where when they went to sentencing, they would try to convince the jury of he acted in sudden passion, which would have reduced his sentence from the 5 to 99-year consideration to 2 to 20 under a second-degree murder conviction. They had that opportunity. They didn't take much of it. They only put the mother on in sentencing, but that's a story for another time. And I think they probably felt they had a better chance of convincing 12 jurors that he acted in sudden passion rather than the judge. Judge Roach, as far as I could tell, and reports coming out of that area in Frisco, is considered a fair judge, a tough judge, more prosecution-leaning judge, a guy who likes to keep his trials on track, running quickly, runs a tight ship. So they probably figured it's probably best we leave that to the jury, since that's more of an emotional determination. That was an abject failure. Obviously, they didn't buy that. And they sentenced him to 35 years. So, as I said, federally and across the states, according to the sentencing commissions on both levels, for someone in Anthony's situation, 20 to 40 years is fairly normal. So in that range, it's a wide range, but he falls in that range. He falls on the higher end of that range. But it is within range. And when you consider that it was a jury and not a judge, because in most states of the union, as I said, only 6 allow jury sentencing in non-capital cases. The rest of the states and on the federal level, judges do it according to guidelines, where they take into account the nature of the crime and your background and whatever aggravating factors are involved. When you take that into account, he's kind of right in that sweet spot. And he did allow the jury. So that kind of creates a little bit of uncertainty. You don't know what a jury's going to do. That's one of the reasons they got rid of jury sentencing in most states and on the federal level initially. And then the states started to adopt that approach, because it was just too much variation. Two guys in the same county could commit the same crime, and 2 different juries could say 10 years, another one says 25. It was a violation of constitutional rights of folks to some sort of uniformity within the system. So when you add that variable, kind of makes sense. Now, what's interesting about that is he got 35 years. In the federal system, for instance, if you get 20 years, you're serving 20 years before you're eligible for parole. You could bring that down with good behavior, etc. In Texas, you only serve 50% before you're eligible for parole. So while that person who was sentenced on the federal level may find themselves eligible for parole, or will find themselves eligible for parole around 20 years or so, Carmelo will be eligible at 17 and a half years. So even though he got the 35, which is higher in that 20 to 40 range, he'll be eligible for parole earlier than anyone sentenced on the federal level. But here's the kicker. And the problem is that Texas has a particularly tough parole system. They're very conservative. They don't, and I could not find any specific statistics on first-time parole board rulings as to how many they let out, but I did find some stats on overall about 33% of violent criminals who come before the parole board get released. Now, that's overall. It could be their 5th time, their 15th time, first time, we don't know. So that's a low number. And I promise you, the first time is much, much lower. If I had to guess, I'd say it was in the 5% range, if that. So the chances of him getting parole that first time after 17 and a half years, I think is extremely low. So that's a problem. The other problem is, once they determine you're not going to be given parole in any particular hearing, they can push the next hearing out anywhere from 3 to 5 years. So if he fails the first time, he could not come back till he's been in jail for 20.5 years, or technically 22 and a half years. So now the years start adding up. And if you're rejected once, then you're rejected twice, 3 times, you start adding on 9, 10, 15 years Now you're getting into a much higher range. So while he's eligible for parole earlier than the average inmate in his particular situation, similarly situated, possibility that he'll get out earlier in Texas because it's so difficult in their parole system is much lower. So that's the reality. That's the math of his situation. I wrote an article. You can find it on my Substack. I kind of go more into detail, some of these numbers and some of these things. It's called The Math and the Myth Behind That 35-Year Sentence, Jury's Youth, and the Truth About Texas Parole. So if you get a chance, head on over Substack, check that out. If you're there already, check that article out. The other thing that I wanted to talk about was I sat down because of the polarizing nature of the Carmelo Anthony trial. And again, I think I've mentioned to you before some of the comments that I get online, some of the things I'm seeing all over social media. This has been a tremendously polarizing case. And it breaks down along racial lines. Technically, white folks see it one way, black folks see it another. Black folks may see it as too harsh of a sentence. Black folks may see it as it was, in fact, self-defense. Black folks may see it as he was railroaded because they hid the trial from us. White folks feel like justice was done, that a young man is dead. He got 35 years. He's a murderer. He meant to do it. He brought a knife. He meant to kill. He was there to kill. He started everything. 35 years is the right sentence. And that's kind of the way it flows. So anyway, I got to thinking about the top 5 polarizing or most polarizing trials of my career. And I've been doing this over 30 years, so we'll stretch back. I want to go through those with you quickly. Now, I want to just tell you, I went through these with Marie in our show, Make It Make Sense, where we dig deeper into about where we were at that time, how old we were, how that might have affected our thinking, what we saw happening around us in these trials. We give it a little bit more of the in-depth treatment. So if you get a chance, check out the latest episode of Make It Make Sense with Mike and Marie, where we dig a little deeper, but I'll go through these relatively quickly with you. Number 5 on my list, let's see, we call this up here, was the Derek Chauvin trial. He was a Minneapolis police officer, and he was tried for the murder after kneeling on the neck of George Floyd for over 9 minutes during an arrest. And this was all captured on video. And I think that's the most memorable thing from this case, was that it was captured on video. And watching that video just enraged the world. Protests were happening across the world regarding this case and prompted tremendous conversations about defund the police and stop, demilitarize the police, conversations about community policing and ways to change things. So this was a real game changer. And again, this was extremely polarizing to this day. People think Derek Chauvin was railroaded and that George Floyd was just a bad guy. I don't know how you look at that video and not see something wrong, not see a crime. I mean, I remember seeing that video, what's wrong with Derek Chauvin? The guy's handcuffed and he's down. You got your knee on his neck. He's telling you he can't breathe over and over. He's calling for his mama. Take your knee off his neck. You got 4 other officers there. I was like, what is wrong with you? Something must not be connecting in Derek Chauvin's brain. So anyway, next case was the Kyle Rittenhouse case. Remember this young man? He he drove down from his home to Wisconsin and from Illinois to Wisconsin to protect some property during ongoing riots there over a police shooting that took place. And he's walking around with an AR-15. I think he was 17 at the time. Same age as Carmelo Anthony. People are killing him for walking around with a 3-inch knife. This cat was walking around with an AR-15 in the middle of a riot. And I watched on tape as police basically deputized him, saw him with the gun. It was a war zone going on. And they're basically saying, hey, thanks for helping us out. Great to see you. It's just like, can you imagine if he was black? That's the first thing I thought. But that he would have been on the ground, face down, face planted on the concrete, faster than you could snap a finger. Then later on, the inevitable happens. He gets involved in something, ends up having to shoot people. And right before that, the cops, as they do in these types of riots, they set up perimeters so that they can contain what's going on. He walks by the perimeter with comes out of the crowd, the smoke, the fire, the ruckus, chaos, with this AR-15 in his hands. Cops don't do anything. They're parked right there. He walks right by him. They don't say, hey, kid, you need to go somewhere. You don't need to be here like that. And that's what sticks out for me in that trial. And also how the judge must have saw his own child in this kid, but very nice to the boy. And I remember that as well. All right, of course, next, number 3, George Zimmerman case. This, I remember, frustrating folks. I was a bit younger at that time and understanding the dynamics with young Black youth in the communities, the difficulties that were happening. And this sort of made hoodies a bad word. And, you got a kid with Skittles in his pocket. You got this guy running around playing cop, confronting the kid, it turning into a deadly confrontation. The kid dies. This guy claiming stand your ground and ultimately getting off. He's had a rough time since then. So karma can be a rough thing. But I remember thinking there was always this suspicion, and there had been a couple of cases that gave you the sense that stand your ground was really about protecting the majority from the minority. That white fear was given more credence under stand your ground than Black fear. So if a Black person is confronted by white people, that fear may not be as important or as sympathetic as a white person confronting a Black person. Even in the situation where the Black person involved is a child. We just saw it in the Rick Chow case. Thinks a kid is stealing water from his store, chases him 130 yards, kills him. Evidence shows he's shot in the back, and yet they called it self-defense. The kid did have a gun, and the gun was found on the floor, but it's dubious. It's dubious. And a lot of people question whether this 60-year-old man could have kept up with a 14-year-old teenager as he ran 130 yards. But the son was right there. Some people think it was the son who did this, and then they set the scene up. No evidence to that. Rick Chow got off. So we see it time and time again. That was the genesis of it, saying stand your ground. Not a good thing for young people, especially young Black boys. Lawrence Powell, that was the Rodney King case. This was really the advent of the videotape era. Videotape of 6, 7, 5 or 6 cops, I forget what it was, beating Rodney King mercilessly. And just again, the outrage and just the luck of having this on tape. Had this not been on tape, this would have been just another guy beaten by the cops. They would have told whatever story they needed to tell to justify his injuries. And everybody would have just gone on their way. This showed us the problems between the police that were policing Black communities. Some of the evidence that came out was really appalling in terms of the way that the cops talked about the people that they were supposed to be serving and protecting, calling them gorillas in the mist, all kinds of things. It's very ugly. The trial got moved to Simi Valley, which was all white, which was the key aspect of this case, and how you could manipulate the system to get the result you wanted. So that's what people saw here, a true injustice done for Rodney King, because they watched on tape as this man was beaten. And for them to get off. But I will say, as an attorney at the time, I was impressed by the defense, because I'm watching the case and I'm watching the defense. Instead of playing the tape as a whole, which is how most of the public saw it consistently, what they did is they broke the tape down into individual moments. And what the claim was, the only time they would hit Rodney King was when he wasn't following their instructions. So they would play the tape, boom, 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 they're hitting him. Pow, pow. Then they back off, and they're telling him, stay down. Rodney King is slowly trying to get up. Boom, pow, ping, pow. They beat him again. And that happened over and over. And that's how the defense broke down the tape. And I tell you, it was interesting. And I said to people, I was working at Court TV at the time, I said, they're going to get off. White jurors are going to buy that. He's going to get off. And in fact, they did. All right. I think at this point, you know what the number one most polarizing case was, the O.J. Simpson case. Do I even need to say? I mean, I think this probably has to be number one on most people's list. Black superstar athlete kills two, his ex-wife, beautiful white woman, another white young man. And I say he killed them. Ultimately, a civil court found by preponderance of the evidence that he did, but not in this trial. And again, this was a function of the system and how you work the system. We saw in the Simi Valley case, prosecutors moved that case to an all-white county and were able to get an acquittal, or the defense was able to get an acquittal. In this case, it was in LA County, where relations between police and the community were awful. And it came to light. Up to this point, it was one of those things that if you lived there, you knew, but nationally, you weren't aware of how bad things were. But it was bad, and it came out in this trial how bad they were. And a couple of mistakes made in the investigation, putting a cop who had racist issues in his past was a problem. Some of the evidence wasn't handled real well. The dream team got put together. Johnny Cochran got involved. And suddenly, things took a turn, and the system, for once, at least as far as black people saw it, worked for us. OJ really wasn't one of us at that point. He kind of put himself in with the white community, but he was a black man, and we said, welcome home, and we were happy. And that's why you saw such a split in the public. White folks watched and were appalled at the verdict. Couldn't believe it. Black people were cheering. Not so much because, and I think if you ask most people, they'll say, the evidence was there. I think OJ probably did it. But that wasn't the point of the cheering. The cheering was that the system somehow had been manipulated. It turned Johnny Cochran into a national hero in the black community. Made the word race card a sort of punchline for just about every case, anytime anybody even mentions the idea of race. But that's what it was about. It was about seeing the system work for a black person for a change. These issues are real, and I'm not sure that rift has ever been fixed. And it's just grown since then, as far as I'm concerned. But anyway, those were the top 5 most polarizing trials. Again, I discussed them with Marie, go a little bit more in depth into how we thought about it. Some of Marie's thoughts are incredible, so if you get a chance, you'll want to check that out. I want to leave you with one thing before I end it today. This came down today, actually. A ruling in the Charlie Kirk case. The prosecutor in that case was found in contempt of court. Why? Because he said things out in public that he wasn't supposed to say. Ethics require you not to do anything to taint the jury pool in cases, especially high-profile cases. So the prosecutor in this case went on TMZ, of all places, and called himself correcting the record on some misinformation online. He wanted to go on and talk about the bullet. There had been rumors spreading around the internet that the bullet or fragments of a bullet found in Charlie Kirk did not match the gun of the defendant. Well, he wanted to go out and make sure everybody knew, no, it's not that it didn't match, it just was inconclusive. There is a difference, clearly. But he didn't stop there. Had he stopped there, he'd have been fine. I don't like that approach regardless, but I mean, every time there's misinformation out there now, especially with social media, prosecutors are going to go try to correct it. Don't like that, but okay, he would have been fine. But then he goes on to say, it doesn't matter because we have enough evidence to convict him beyond a reasonable doubt. Boom. That's the hammer. You can't do it. That is tainting the jury pool. TMZ is a very popular show. Defense filed a motion, and the judge found him in contempt, and I'm glad he did, because this is something I've railed about for years. During my years on court TV, I talked about, prosecutors often, especially early in high-profile cases, want to control the narrative. They put stories out there, they put their evidence out there, they read their indictment to you of all the things that they've found and the strength of their case, and defense attorneys can't say anything. If they do, then motions will be filed by prosecutors saying, oh, they're talking, they're poisoning the jury pool. And gag orders are put out. Nobody can see anything after that. But they've already controlled the narrative. And that was part of what was happening here, but the judge said, I'm not going to let that happen this time. So the question becomes, what's the remedy, right? The defense said, look, this is egregious. And it is. And they said, because it's egregious and we can't guarantee now that he hasn't poisoned the jury pool, we want the death penalty off the table. Because Tyler Robinson is facing the death penalty and the murder of Charlie Kirk. The judge says, well, hold on, wait a minute. That's disproportionate. It's a disproportionate remedy. So what he has decided to do is he's going to expand the jury pool to make sure they can find impartial jurors. And it's going to be special questions drawn up that both parties will use to make sure that whatever jurors end up on that jury can be fair and impartial and have not been poisoned by that information put out there by the prosecutors. Fair enough. I think that's probably the right approach by the judge. No need to drop the neutron bomb on the case and say no more death penalty. And this approach, I think, will make sure, and again, at the end of the day, all you're trying to do is make sure that the defendant gets a fair trial. You could eventually, if it was so bad, you move it out of the county, move it somewhere else. But again, with those words, TMZ being national, that's tough. So the defense said, hey, let's give it a death penalty. The judge said no, and I think that might have been the right decision. But I just wanted to drop that in because that happened just today, and I wanted to make sure that you were aware of it. So that trial will be continuing on with those things put in place by the judge. All right. That is going to do it for me today. Thank you so much for listening to Legal View with Michael Ayala. Before I go, I just want to give a shout out to my mother-in-law. We're going to be burying her and celebrating her life this coming week. She passed away recently, and she was just a beautiful person. I had the privilege of living with her. She was living with us as she was allowed to age in place. So glad to be able to do that. It's just a good thing. Take care of your elderly. I watched as dementia sort of took over her, and the person who she was disappeared into that dementia. Occasionally there'd be little lights of the old person, and you embrace those. But now she's moved on, and well, R.I.P. to Grandma Jewel Hernandez. All right, guys. Again, thank you so much for watching. Make sure you check out In Session with Michael Ayala and Judge Ashley Wilcott. We have episodes up of that. Make It Make Sense with Mike and Marie. Episodes up of that. And particularly in Session this week, we talk about some interesting topics. We discussed the Luigi Mangione situation with the defense first admitting that he was the person who did this and then pulling back on their defense because it could affect his federal case. We talk a little bit about concierge judges, where the moneyed class are able to hire judges to take care of their cases and keep things private. So that could be problematic. Judge and I discuss that as well. So some interesting topics there to dig into. All right, guys, again, thank you so much. Have a wonderful afternoon. I'm Michael Ayala, and this has been Legal View.